Hello, everyone. Thank you for joining us on the program. I am Ladi Adebutu. You can join the conversation now on X, formerly Twitter, using the hashtag Beyond100Days and tag @TVC News NG. Let's begin in Lagos, where the Court of Appeal, in a split decision, affirmed the re-election of Abiodun of the All Progressives Congress as winner of the 18th of March governorship election in Ogun State. The majority judgment delivered by Justice Joseph Ikyegh dismissed the appeal filed by Ladi Adebutu, candidate of the People's Democratic Party in the 2023 governorship election. But the minority judgment delivered by Justice Jane Inyang allowed the appeal and ordered the Independent National Electoral Commission to conduct a fresh election within 90 days. Justice Hamidu Kunaza of the lower court had, on the 30th of September, dismissed the petition filed by the PDP and Mr Adebutu for lacking in merit. The tribunal held that the petitioners failed to prove allegations of overvoting, rigging and non-compliance in the election. Not satisfied with the judgment, Mr Adebutu and his party approached the Court of Appeal to challenge the tribunal's ruling. The court held that the appeal lacked merit as it found no substance in it and subsequently dismissed it, affirming the earlier decision of the tribunal without costs. In the majority judgment, the Court of Appeal held that it is the petitioner who bears the responsibility to prove that an election was marred by corrupt practices and that appellants did not so prove. The court held further that the appellants did not prove the allegation of certificate forgery against Governor Abiodun and noted that the tribunal did not believe the evidence of certain witnesses because of their demeanors and because of the corrupt nature of their testimony. It maintained that the appellate courts generally do not interfere with such assessments and that the assessment of the tribunal is undisturbed. On the issue of disenfranchisement raised by the appellant, the court held that it was the duty of the appellants to prove same by calling voters who could vote but were disenfranchised, adding that in this petition, rather, the appellants did not call any such voter. Welcome back. Now, let's get into the conversation. Legal practitioner Jide Ologun and political technocrat Dr. Dayo Kade join us on the program. Let's begin with you, Dr. Ologun. Ogun State governorship election in focus. Split decision coming from the Court of Appeal. In simple terms, what does this mean? Does it affect the legitimacy of the governor?
Thank you very much. Let's start by laying a foundation that if you look at Section 239 of the Nigerian Constitution 1999 as amended and Section 285 subsection 2 of the same Constitution and Section 65 of the Electoral Act 2022 as amended, the gates have been kept open for the tribunal to intervene should there be those who acted actively during elections and are not satisfied with the results of the elections, knowing that constitutionally so, INEC has been mandated to be the umpire. So if the parties who went to the tribunals did not go, we won't have this discussion we are having now. And having said that, it's again a way of upholding the fundamental human rights that they have not just as parties, but as candidates in elections. And of course, when these parties approach the tribunal, as the case may be, you have Section 131 of the Evidence Act 2011, Nigeria, that says whoever desires any court to give judgment as to any legal right or liability dependent on existence of facts must prove that those facts exist. So all the parties who approached the tribunal were given the opportunity to present their grievances and defense before the tribunal. And of course, if some are still not satisfied at the level of tribunal, you move to the appellate level. And let me say this, in the case of governorship election, there are 3 steps: the tribunal, then the appellate level, which is the Court of Appeal, and the final one, which is the Supreme Court, the apex court in the land. And in the case of the presidential election, there are just 2 steps. You talk about the tribunal, which is at the Court of Appeal level. and after that, the Supreme Court, which is the apex court. And I expect that if these provisions have been put in place by our Constitution and other enabling laws, then it means that it's legitimate to approach them, particularly when it becomes necessary to test the credibility of our democracy. So, and I think all we have been observing and reading is a mixture of decisions of these judicial interventions. And of course, the opinion polls that we have all around, but let's say this categorically. There are three arms of government: the executive, the legislative, and the judiciary. And I have always projected my position that what Section 4 of the Nigerian Constitution 1999 as amended says is that the legislative arm, the National Assembly, shall make laws for the peace, orderliness, and good governance of Nigeria. So they also should be monitoring the trends from these judicial interventions and see how we can fine-tune our laws to ensure that judicial intervention is reduced.
All right, Dr.
When
Ologun.
it comes up.
Okay, we'll take it from there in a bit, but quickly let's bring in Dr. Kayode. More and more, we are seeing politicians who are dissatisfied with the outcome of the election process approaching the court. But sometimes they are unable to prove their case, because in this case in question, for instance, the court, that the tribunal had declared that they were unable to prove allegations of overvoting, rigging, and non-compliance in the election. But of course, they approached the Court of Appeal. What would be your intervention to politicians going from one level to another?
Yes, thank you, Abosede, for having me this evening on these particular discussions. Just like Barrister Ologun laid a foundation, let me also lay a foundation in Yoruba, and I will now interpret in English. My adage in Yoruba says, "Láti kékeré náà ti máa ń pẹ̀ka ìrókò." And the second one says, "Wọ́n ní amúkùn, ẹrù ẹ̀ ó wọ́." Amúkùn ní òkèlè ń wò ẹ̀ wò sàlẹ̀. That is to say, in summary, when you sow wind, you are definitely going to reap whirlwind. But if you are able to control what you have sown, then you will be able to control that whirlwind. And what am I saying? What we are saying today, as regards electoral petition, the judgments in either tribunal or appeal or whatever, had started from the presidential appeal court and Supreme Court, whereby certain issues were raised as being illegal. But don't let us go to that side. But were raised as being illegal. And a larger percentage of Nigerians felt that the judiciary had validated things that are not to be validated. And this can be supported by what our retired Justice Datijo said, also corroborated by what Barrister Muiz Banire said a few days ago. That is to say, the judiciary that is supposed to be where commoners will go to get succor at turned to something else. But Muiz added, listen, Abosede, I'm sorry. Muiz added that all that we have been seeing is embarrassing. Now let us go to Ogun State. The petition of Ladi Adebutu was beyond overvoting and certificate saga. It is inclusive of what the electoral law says, what the guideline says, that when the number of votes that the leading candidate is having to lead, the following one is less than the number of votes that is involved in other areas that we are still expecting elections to hold, then that election is inconclusive. What do we see about that? We did not also talk about what have been happening in other petitions.
Yes, we'll get to other petitions. Dr. Kayode, we'll get to other petitions shortly, but let's stick with Ogun State. And let me bring this next question to Dr. Ologun. In this case now yes, we'll get to that, Dr. Kayode, if you would allow me. Dr. Ologun, in the case of Ogun now, it's a split decision. Would you say this is a ray of hope for the People's Democratic Party and its candidate, Ladi Adebutu, to approach the Supreme Court?
Very much for that question. Let me amplify the fact that the decision of the appeal court in the case of the governor of Ogun State is not final if PDP decides to head to the Supreme Court. The final decision will be at the Supreme Court, and Supreme Court became the apex court in the land since 1963 when we became a republic. And I have looked at some of the expressions of the justices, and their position is a two in majority and one dissenting voice. So that keeps the intervention of the Supreme Court open. And what the appeal court did was to dismiss the appeal filed by PDP, and they declared that the appeal, it lacks merit, So, and like I mentioned earlier, which is very important, and Dr. Kayode mentioned it now, you see, if there are things you should do pre-election, please do not ignore doing them. For instance, if you look at the case of Kaduna, you look at the case of Kano, you start reading about issues of the candidates that went ahead to seek votes, not being a member of the party in line with the expectations of the Constitution. For instance, if you look at Section 77 of the Electoral Act 2022 as amended, it makes a requirement that the register of the party should be made available, not later than 30 days, to the date fixed for the party primaries, congresses, and conventions.